Okay, good morning, everybody, or good afternoon, depends where you are.
Mhm.
Thanks for being here. We'll give everybody just a minute or two to continue to join and to get settled in, and then we'll get started. All right, looks like most people have joined. We're going to get started. So this is the 35th installation of the Panage Training Academy. So welcome to that. Today we're going to be talking about IP protections for new plant varieties, options and strategies for securing and enforcing protections. Before we get started, I'll just give a quick 30-second background on ourselves. I'm Travis Bliss. I'm a partner at Panich Schwartzy. Panich is a IP boutique. We have about 30 attorneys, all focused on IP. Stephanie and I, a large part of our practice is in the horticulture and agriculture space. So we deal a lot with plant IP rights. Before joining Panich, before joining law, I got a PhD from the Department of Agriculture at the University of Delaware. Then I went to law school with the goal of being a IP attorney focused on life sciences and agriculture and horticulture, and that is where I have landed. My practice sort of spans the whole timeline of IP rights from counseling and strategizing on which IP rights to obtain, and then obtaining rights, licensing and monetizing those rights, and enforcing rights. So sort of the full timeline of IP, but my practice is largely focused in the life sciences, and a big piece of that is in agriculture and horticulture.
So I'm Stephanie Small. I am a patent agent, which means that I can practice only intellectual property law. I have a PhD in cellular microbial biology, and my focus was mostly genetic. Prior to joining a law firm, I started my intellectual property career in-house at a biotechnology company. And then I've been in law firm for a long time. Travis and I have worked together for longer than I care to admit, a very long time. My practice overlaps what Travis shared. And so I also help with all things life science. A big part of our practice, again, is in the horticultural space. And we like to do both sides of intellectual property, helping people obtain their rights and also helping people defend their rights. And I think that is unique among us. And we'd like that because when we're helping people obtain their rights, we can put on our litigation hat and think through future potential problems. And then when we're in a litigation, we can put on our prosecution hat and kind of understand why we got to where we were. Um, uh, the goal of today is to really share some basic intellectual property information. Our view is that intellectual property is should help your business. And it's how you use intellectual property and what type of intellectual property you obtain is really about your business goals. So having said all that, we want this to be as helpful of a conversation as possible. We're monitoring the chat. So when Travis is speaking, I'll monitor the chat and I'll interrupt him with questions. And same thing when I'm speaking, Travis will monitor the chat. So if you have questions, please ask him. Don't wait for the end. We want to make this as helpful as possible. Just a reminder that the session is being recorded and will be available on our website by the end of tomorrow. Again, feel free to ask questions. And for those seeking CLE credits in Delaware, Georgia, is that GA, Georgia,
Yeah.
Pennsylvania, or Virginia, make sure to stay for the entire session and respond to the 2 pop-up polls and fill out the feedback survey at the end.
Okay, we'll get started. So just at a high level, what we're going to sort of walk through today, I'm going to start by talking about some IP basics for plant IP rights, why we have plant IP rights, what the basis for them is, their usefulness in promoting progress, and what you get from having plant IP rights. Stephanie's then going to walk through the 3 types of varietal IP protection that you can get in the United States. The U.S. is unique in that aspect, as we'll talk about. Then we'll talk a bit about protections in other countries, just briefly. We'll talk briefly about the impact of other people's IP rights on your freedom to operate. And then we'll talk a little bit about trademarks as an additional layer of protection in the agriculture, horticulture space. And then if we have time for it, we'll talk about licensing novel varieties at the end. Licensing schemes can get rather complex, and it's a fun thing to look at. So with that said, so I'll jump right in. So the legal basis in the U.S. for plant IP rights. So if you go back, patents in general are obviously in the Constitution. The first patent law was actually put in place in 1790 in the U.S. But the U.S. was the first country in the world to specifically provide for IP rights for novel plant varieties. And that was in 1930 with the passage of the U.S. Plant Patent Act. And the Plant Patent Act provided rights specifically for asexually reproduced plant varieties. So since 1930, you've been able to get a plant patent that protects an asexually reproduced variety. The rest of the world then followed on and frankly improved upon our system a bit. The International Union for the Protection of New Varieties of Plants, which is always referred to as UPOV, was established in 1961. UPOV is a convention. It's a treaty among many countries at this point. And there have been 4 UPOV conventions that people could sign on to. Those were in 1961, 1972, 1978. And the newest UPOV convention that many countries have signed on to is the 1991 UPOV standard. So UPOV allowed for, in general, protection of any type of plant. It gives an IP protection for any type of plant. So the U.S. from 1930 on was focused on asexually reproduced plants. UPOV then was passed starting in 1961, and that was for any type of plant. The U.S. passed its Plant Variety Protection Act, which is the PVPA, in 1970, and it has since updated its act to be compliant with the 1991 UPOV convention. But the U.S., because we already had the plant patent system that covered asexually reproduced varieties, the U.S. Plant Variety Protection Act was specific for sexually reproduced varieties, so seed reproduced plant varieties and tubers. And that was true from the time it was passed in 1970 up until 2019. And in 2019, things changed because the 2018 Farm Bill contained a very small change to the PVP Act that had very small change as far as text change, very big as far as the impact. It expanded PVP protection to allow you to get PVP for asexually reproduced plants. So then we had overlapping systems. In addition, the U.S. also allows protection of plants using utility patents, and that is relatively unique in the world. There are a few countries that allow that. Australia is another example where you can get utility patent protection or regular patent protection for plants, but most countries don't allow that. So historically, the utility patent system was really only used to cover seed reproduced plant varieties. And that was really a result of the enablement requirement. So enablement required that, or in order to enable a patent that covered a plant variety, the patent office had held that you have to make a seed deposit. So you had to deposit seed or a biological sample of the plant with a Budapest Treaty approved laboratory. And just technically, up until recently, there was no real way to make a deposit of an asexually reproduced variety because you couldn't deposit seed, so there's really no way to satisfy that enable requirement. Recently, technical advances have happened that have now opened up utility patents to asexually reproduced varieties. So that wasn't a legal change as much as a technical change, and then the openness of some of these approved labs to accept tissue culture deposits. So now you have this third system that you can use for either sexually or asexually reproduced varieties. So we have three separate systems that run in this country simultaneously. So there's three options, and Stephanie's going to talk through those a bit. So that's sort of the what we have and how we got there. The why IP rights exist question, there's been some interesting studies that we'll talk about, or an interesting study that looks at the effectiveness of plant IP rights in promoting the progress of science and the useful arts. So the reason for IP rights in general is, as it says in the Constitution, to promote the progress of science and the useful arts. And effectively, you strike a deal with the government when you get IP rights. And then that deal is, in exchange for teaching the world how to do something, the US government gives you a limited monopoly over that invention. So IP rights are supposed to create an incentive for people or companies to invest resources into developing new and better things. So the goal there is, if IP rights are functioning, they should promote progress. You should see, from the plant variety space, you should see an improvement in varieties, an improvement in things like yield or water usage or drought tolerance, things like that. So the question with that, and people debate this a lot, is, does that system really work? Do IP rights actually promote the progress of science? And in 2022, the university big brains, the people at Harvard, said it does. So they did a study entitled Flowers of Invention, Patent Protection, and Productivity Growth in U.S. Agriculture. That was the title of the paper that came out from the study. And what they looked at was investment into plant varieties and the new plant varieties that were developed after a country began allowing there to be IP protection for plant varieties. So immediately after IP protection became available for plants in a country, what happened to the investment into the space and the plant varieties that were produced and introduced into that space? So some of the things they looked at were the impact of the varieties that were then introduced on yield, profits, land value, all these things. And what they concluded from that is that the introduction of patent protection into an area led to a substantial increase in novel variety development. And they looked at why that happened, and they said the development was driven by increase in private sector investment, and that led to an increase in crop yields. So ultimately, their conclusion was that the prospect of patent protection spurred technological progress. It did work. If once they allowed plant IP protection, you got increased investment and you got better varieties being developed and introduced into that country, which had effects like improved crop yields in that area. So it does work, which was a nice thing to see, because there is a lot of debate about that happens in academics. So that's the sort of does it work? Now we'll move on to what do you really get when you have plant IP rights? And this will sort of lead into Stephanie's discussion of the three types in particular. So intellectual property is essentially an exclusionary right across the board. It gives the holder of the IP the right to stop others from using their invention or doing things with their invention. It doesn't generally give the holder the right to do something. So because I have a patent on a plant variety, or a PVP certificate, say, on a plant variety, I may not be able to practice my own plant variety because it may step on someone else's toes, but I can stop someone from practicing my plant variety. So plant IP rights specifically give the holder the right to exclude others from, in effectively every case, reproducing or duplicating your specific variety that you're developed. In addition, depending on the type of right you have, it may also give you the ability to exclude others from using your variety to generate what we generally refer to as downstream varieties. And when we talk about downstream varieties, we're really talking about sort of three different things. One of them is F1 seed for sale, which means F1 seed that's developed by taking variety A and crossing it with variety B. It generates seed, and I'm going to sell that F1 seed. And then I'm going to do the same cross again. A times B, generate seed, sell that seed. So that F1 seed is its own hybrid variety seed that's being sold. So that is one type of downstream variety that we'll talk about. Another is essentially derived varieties. And these are generally viewed as varieties that are developed that have only a single parent. So typically they're things like sports or mutants that come out of a field of growing a variety, and one of them comes up different. You're growing a field of plants that have white flowers, and now something pops up and it has pink flowers. That's some sort of sport or mutant. That is often an EDV. Another way you could get to EDVs is through genetic editing or genetic modification. There's a question mark on this one because there's some debate, depends on which side of it you're on, whether you think a genetically edited crop is an EDV or not. But that's essentially derived varieties, generally things that have a single parent. And then we have novel varieties that are developed through breeding. So that's traditional breeding. I'm going to take this variety and I'm going to cross it with this other variety. I'm going to come up with something new, and then maybe that's asexually reproduced from there, or back crossed and turned into a true breeding variety. So those are really the three types of downstream varieties we're going to talk about. So with that, I'll let Stephanie go through sort of the three types of IP protection and how they differ largely in regard to coverage of those downstream varieties.
Thanks, Travis. I'm going to pass this over so you can monitor the chat. So there are three types of IP protection for novel varieties in the United States. The first that we're going to discuss is plant patents, and these are issued by the U.S. Patent and Trademark Office, otherwise known as the USPTO. And of the three we're talking about, these are the easiest to obtain, the quickest to obtain, the cheapest, but also has the narrow scope of coverage. The other one we're going to talk about is utility patents, also issued by the USPTO, and these are on the other end of the extreme. So they're the most difficult to obtain, the most expensive, but the payoff is that they have the broadest coverage. And in the middle are plant variety protection, PVP certificates. And these are issued by the U.S. Department of Agriculture, the USDA. And this is under the UPOV convention that Travis was talking about, and would be akin to other plant breeder rights that we've seen around the world. There are similarities between these three types. You should give your new plant variety a name, and that name should be a boring, unpronounceable name like SGS 123. Do not use a name that might be used for branding, because your variety name by definition is generic. So whatever name you give your variety cannot be trademarked. So you want to give it some sort of boring name that the public won't latch on to use as a brand for your variety. So we always something incredibly boring. The time of filing an application, the novelty bar is important, incredibly important, all three types. Certain activities can start the clock for filing, and these activities are a little different between USPTO and USDA, but the same between all three is you must file 1 year from activity in the US in any three of those types of IP. There's also overlap of disclosures required. For each of these three, you need a description of your new variety, and you also have to have a breeding history, so identify the parents. You also must identify the inventor or breeders, and this is different definitions between the USPTO and the USDA, and we'll talk about it a little bit, but you have to identify the people that are involved in generating the new variety. Basics of plant patents are they're only available for asexually reproduced varieties, so ornamental flowers, fruit trees, other types of avocado, sterile turf graft. It requires a detailed botanical description. You must describe the different properties of the variety. You must also distinguish the variety from its parents and also the most similar varieties available. Plant patents, there are no requirement from data from comparative field trials, and there's no biological deposit required. The other thing is even though it requires a very detailed botanical description, you aren't required to have that when you file the application. So those botanical details you can add to the application after filing. Plant patents usually take 4 months to 12 months to get allowed, a very, very high allowance rate with plant patents. Of the three types we're talking about, it's the lowest all-in cost, and costs are paid by the time the patent issues, meaning that there are no once the patent issues, there's no maintenance fees or downstream fees. So once you get it issued, you have that patent for the 20 years. And there's no deposit fees either because you don't have to make any sort of biological deposit. So, our first poll popped up. So if you want to take a moment and answer the poll if you're looking for CLE credit. So for inventorship and plant patents, and also this goes for utility patents as well, conception is the invention. And there can be multiple inventors, and oftentimes there's multiple inventors for a single new variety. So some of the questions we kind of think about of who is the inventor is who decides the cross. So who decides what parents to cross? And so the person that actually performed the cross may or may not be the inventor. So if I say, Travis, I want to develop a new rose with black petals, and I just tell him that, and then he figures out, oh, I'm going to do all these crosses. He's an inventor, not me. But if I say, I want to develop a black petaled rose, and I say, I think we should cross parent A with parent B, Travis, go cross parent A with parent B. I'm the inventor. He is not. He's a pair of hands that just is going out doing what I'm asking him to do. Another question would be if it's a sport or mutant, who identified it? Who discovered that sport and mutant? And then another question would be who did the selection of the new variety? So even though I said to Travis, do cross parent A with parent B, Travis does the cross, but then he's like, oh, look at this one. Look at this. This one's really interesting. We should develop this one. We should select this progeny and develop it and see what it does. And he does that. Then he's also an inventor. So it's a lot of questions to think about for inventorship with the USPTO. For plant patents, the major hurdle for plant patents is the novelty bar. So there's a very, very strict novelty bar with USPTO, which is there can be no sale, offer for sale, or public availability of the variety anywhere in the world more than a year before filing the application. So just a disclosure about the variety should not be novelty destroying. For example, if the breeder goes and talks to the public and is like, I have this great new variety. I can't wait for the public to see it. It's beautiful. It's my black rose. It's beautiful, blah, blah, blah. That shouldn't be novelty destroying, just a description of the plant. However, we would like to caution that even if you have that type of disclosure, you're going to have to argue with USPTO about it. And then the other part that we really want to highlight is USPTO has greatly improved their searching capability of finding disclosure. And because they're finding more disclosure, they're asking more from the applicant and requiring evidence to show that it hasn't been offered for sale or available to the public prior to a year. So that's a lot of work. And the other part of it is these days, you really need to be careful with your trials and trade shows. So there was a patent that was, so there was a display of an ornamental at an after-hours show at Home Depot, and that event was shown to be novelty destroying for obtaining a plant patent for that ornamental plant. And also, we're starting to see that public fruit tastings could also be problematic. So the scope of protection for a plant patent, as I said, the plant patents are the easiest to obtain, the cheapest, but the trade-off of that is the scope of protection is the narrowest of the three we're going to talk about, and it's defined by the statute. So it gives you the right to exclude others from asexually reproducing your variety, making, using, or selling those asexually reproduced plants to the US, including whole plants and parts. So that kind of sounds like a lot, but patent exhaustion limits the ability to go after anyone who bought the plant legally and is using it to produce harvested material for breeding. So that's all to say, if somebody legally buys your plant, they can do anything they want with it apart from asexually reproducing it and making a new plant. So they can take your plant and they can use it as a parent for breeding. They can harvest any material from that plant that they bought. All that being legal, your plant patent doesn't stop anyone from doing that. So here's an example of a plant patent. This is the Rad Raz, which is under the trademark Knockout Rose. And so, as I mentioned, for making your application for a plant patent, you need to collect all of the botanical descriptions. But if you don't have to have all that in the application prior to filing, you can supplement it during examination. And then the most critical thing for a plant patent is to think about that novelty bar, think about your activities, and be ready to file your application in view of any activities that you've done with your variety. The second one we're going to talk about are varietal utility patents. So this is the other extreme. How are we doing?
So we did have one question. The question was, were the Home Depot display and fruit tastings identified by the patent office or uncovered in litigation? What's the duty to disclose displays and tasting as in an IDS? So the Home Depot, it was a patent infringement case. They brought infringement suit for I think it was against somebody who bred with it. And it came out during litigation that the plant had been displayed at Home Depot and was found to be an invalidating prior public use. So the patent office in that instance did not find it. Today, and that was now a few years ago, what we're seeing today is the patent office is doing a very good job of finding public displays. So if you put a flower in some sort of rose trial, flower trial, and there's anything published about it, including Facebook posts from people who attended, which is what they're finding now, then we're getting either rejections over it or Section 105 requests for information, where we have to just describe what happened there and be able to justify that it was, if it was within a year, that it was with permission of the plant owner. So yeah, I think though it wasn't found during prosecution for that case, and then we haven't seen one with fruit trials that were found yet, we are seeing the patent office doing a better job. As far as the duty of disclosure, I think you do have a duty to disclose if it was publicly available more than a year before, or actually they're going to ask you to disclose even if it was less than a year before. They'll ask for your first disclosure in these requests for information. And so I think what we're seeing is we're getting these requests, and we just have to justify that it was either within a year, or if it was outside a year, that it was not an enabling disclosure, according to the old case law that says merely a mere publication of the plant without public availability of it, somebody being able to take a sample of it, is not enabling and is not invalidating. So that's sort of where we are right now, but definitely we're seeing a lot of case law emerging now. There's been most of what has happened as far as invalidating disclosures has happened very recently.
And it's clear the USPTO has new searching capability, so that's adding to what we're seeing now from the USPTO. And some of the things we've had to do when the USPTO does find these kind of things is, for example, if it's a rose trial, to go to the regulations of that rose trial to show that the plant was never actually in the public, and it was protected and under the hands and care of the organizers. It went from the owner to the organizers, and it wasn't ever an offer for sale or sale or public availability, but to try to find rules in that under that trial for it. We recommend making sure that stuff is there, or doing your own letter to make it clear that you're not making a public display of your variety in these trials.
Two other questions. So for trials, are trials, for example, taste tests used during development selection of the variety considered novelty destroying? So there hasn't been a case that happened in yet. I think you have to make sure that whatever taste testing you're doing falls solidly within the experimental use exception, which can be a little problematic for asexually reproduced varieties, because in one recent case, one of the real issues that came up was that the plant was ready for patenting long before they did some of what they considered experimental use, because it was ready for patenting once they had developed a new variety, they recognized it as something new and novel, and they asexually reproduced it. They had checked all the boxes of what's required to get a plant patent. So I think you have to make sure that your testing agreements under which people are trying things are clear, that you're testing to determine whether it is ready for patenting, to determine whether it is truly a new variety and it reproduces true to type in various conditions. So there's some buzzwords and catchwords we frequently put in testing agreements to try to make it clear that it is experimental use and not commercial testing. And with regard to taste tests that I think would be done publicly, if it's sort of commercial taste testing, that could become problematic for sure. You're considering it part of the development or selection process, but if it's the commercial aspect of it, I think that could be problematic.
And just to add on that, just some practical advice. So I recently saw a public taste testing where it was just like a Google form that you could sign up to do this taste testing, but the fruit was actually labeled with the variety name. And then a person that attended, just in the public that attended the taste testing, wrote a blog all about it and described it. And clearly it was, that would be a very difficult thing to overcome through the patent office eyes. It's somebody in the public that's used it, tasted it, so it's difficult. So our advice is if you're doing taste testing, don't even use the breeder's number, just use ABCD and have your own list of what that means. So it's really unclear what the public is seeing and observing. The reason I say that about breeders codes is because back in the day, you would just use your breeder's code, and then when you were ready to file your application, then you'd have your variety name, and they were separate and they were distinct, and it was fine. The USPTO is asking for all names. So they're asking for all names, all those breeder names, so that they can do the searches for it. So that's not really a good path forward. So you need a change of, the industry needs a change a bit of how they've done things in the past.
Yeah, and the issue with that, the plant on display at Home Depot, the court said that it was in public use for its intended purpose because it was an ornamental, and the intended purpose of an ornamental is to look at it and view it. So if you sort of transfer that to the fruit industry, the intended use of a fruit plant is to eat fruit. So if you're allowing people to taste the fruit, arguably it's being put into public use for its intended purpose. So again, making sure that there's good controls that allow you to say it's experimental use, including, non-disclosures or, something that somebody's signing indicating that they recognize this is an experimental test and they're not allowed to disclose it. One last question. For plant patents, could you stop a competitor from gene editing your variety if this necessarily involves asexually reproduction of the variety?
Oh.
I think so.
Yeah, I think so.
If they take it and were to take the plant material and just gene edit it, and then what they reproduced was a gene edited version for a plant patent, arguably it's a new variety. It's a derived variety, a downstream variety. But probably some of what they reproduce would be the same.
I like it.
I like it. That's a good argument. So that's a good thought. I like that thought.
Yeah, so for plant patents, it's pretty cut and dry because it's statutory limitation. So it's pretty cut and dry that it's asexually reproducing the plant. So I think if you can make a good argument that the person is asexually reproducing the plant, I think it's a good argument.
That's a good argument. Yeah.
So on to utility patents. They're available for asexually and seed reproduced varieties. They require the same details as the plant patent plus a lot more. So anything to support the claims that you're trying to obtain coverage for, you need to have support for, like words for in the application. You need to also make a biological deposit, whether that be a seed deposit or a tissue culture deposit. It takes a lot longer for these two applications to get allowed. There's a much lower allowance rate, and that depends on how broad of scope you're trying to obtain. The cost is much more. It's the most of the three that we're talking about, and that's because the application needs a lot more attention to it. The back and forth with the patent office is a lot more, and it's just a harder application to get through. In addition to the fees through issuance, there's also maintenance fees over the course of the patent life, over the 20 years of the patent life. That's $6,000 for small entity and $14,000 for large entity. And then on top of that, you'll have a cost for your deposit, which isn't much for seed, but for asexually reproduced varieties, it's about $4,000. So I'll go through this quickly. For inventorship is very similar for utility patents as it is for plant patents. The difference is that inventorship is based on the claim scope. So depending on which claims are actually in the patent describes is who decides what the inventors are, but it's basically the same basics of the plant patent, plus if you did any genetic modification or special mutations or anything like that that was added to the claims. Maybe there's additional inventors. The novelty bar is very similar to what we talked about with the plant patents. And we talked about these points already about using not just using a breeder code in your trials, especially your public taste trials, just using ABCD. And then Travis was mentioning having NDA or published rules for public viewing. Make sure I covered everything there. Yeah, okay. And unlike plant patents that the scope of protection is statutory, here for utility patents, the scope of the claims dictates the scope of protection. So it generally gives you the right to exclude others from making, using, or selling your claimed invention. And what that claimed invention can vary. So generally it's the same as a plant patent. So specifically your new variety. Plus people generally try to get other things like breeding with your new variety, using the variety, produce F1 seed, essentially derived varieties, and marker hunting with the variety. So here's an example of a utility patent. And I have the claims here to the side, which I can barely read. So, but it is, so the first two claims are generally just to the plant itself. Claim 4 is, introducing a plant that's been using your plant variety and introducing a transgene. And then 6 is the soybean produced, in this case, it's a soybean patent. So the plant produced by growing the seeds of the transgene. And then 7 is introducing a mutation. And then 9 is an F1 soybean produced by the method of the mutation. And then 8, sorry, I can barely see, apologize. 8 is the traditional breeding. So it's a method producing a soybean, crossing your soybean with another soybean, and then the downstream target of that. So those are just, there's more claims in this patent, but those are kind of the highlights that you see in utility varietal patents. It's generally, like we said in the beginning, it's generally the variety itself, then using the variety to create either downstream targets in some way. For a utility patent, you need to have all the information that I described earlier. But the difference between a utility patent and plant patent is you cannot add this information later during examination. You have to have every piece of your information in your application before you file. So this can sometimes be problematic because if you have a novelty bar and you have to quickly file your application, there's strategy behind that of what you could do. Maybe you quickly file a plant patent and then you file a utility patent later, but your utility patent has to be complete and have all the information to support the claims that you would like to obtain prior to actually filing your application.
We had one question on that. So does the required deposit need to be accessible without restriction, or can the patentee impose restrictions on public access to the deposit?
Great question.
It is. So the deposit has to be made with a deposit facility that complies with the Budapest Treaty, which is the international treaty relating to biological deposits. In the US, those labs are required under patent law to make the deposit material available when the patent issues for a utility patent. So while the patent application is pending, the deposited material is not available. Once the patent issues, the deposited material is theoretically available to anyone, but anyone who gets it takes it subject to the patent, and the patentee will get a notification that the material has been given to person X. So typically, and they take it subject to a material transfer agreement that says they won't use it for certain things that would violate the patent application. There is a pending case where Corteva has brought a lawsuit against Inari for Corteva made a biological deposit of, I think in that case it was seed. Inari took the seed deposit, did phytosanitary testing on it, and exported the material to Europe, where it then did genetic editing on that plant material. Corteva sued, alleging that the use of the export of the plant material effectively was a infringing use. And so far that appears to hold up. The court has said that just simply doing phytosanitary testing, it could be an infringing use of plant material. So while people do have access to it, the access should be very limited. Stephanie's going to talk about deposits for PVPs, but just to highlight the difference, PVPs, you have to make a deposit of seed as well, but the seed deposit is not available until the PVP expires. So it's a little bit better on that front.
Mm-hmm. The second poll is just come up. So if you'd like your CLE credit, go ahead and answer that. So for PVPs are in between, I feel like we're getting close. Yeah, okay. Well, I'll go through this quickly. So for PVPs are in the middle of the two different types of patents. It's available now for asexually and sexually reproduced varieties. The application is a little different. You must have a detailed botanical description, breeding history, selection process, and you must have data from comparative field trials for DUS testing. The USDA is a lot easier than some other jurisdictions. So you don't have to have government oversight. You just do the trial and report the data. And also you could use a DUS trial from a different foreign jurisdiction, and the USDA will accept that. So it's as easy as it gets, I think, for under the UPOV PVPs. And you must make a seed deposit. You do not need to make a tissue culture deposit for the foreseeable future. This was required when PVPs were initially became available for asexually reproduced varieties, but the USDA essentially said the technology isn't there. They would like to see that tissue culture is available for the majority of types of plants that would be getting PVP protection, and it's just not there yet. So until that technology catches up, they will not require the tissue culture deposit. So meaning if you file an application now, you will never have to make a tissue culture deposit on that variety, even if the USDA changes the rules later.
We did get one more question about deposits. For an F1 hybrid, what deposit is needed, the F1 hybrid or the parents? Typically both, because the enablement requirement requires that somebody be able to reproduce your invention, and to reproduce the invention, you typically have to deposit the parental seed. You usually deposit the F1 seed as well. And that's true for both PVPs and for utility patents.
PVPs are in the middle of everything of the three types we're talking. It takes about 6 to 18 months to get allowed. It's a very high allowance rate, and the cost is in between the two as well. All the government fees are paid up front, so there's no downstream maintenance fee. One thing I wanted to talk about is breeder versus inventor. So a breeder for a PVP is different than in the inventorship analysis we talked about for patents. So a breeder can be one or more person, and it can also be an entity. So a breeder can be the person who bred or discovered and developed a variety, or the employer of that person, or a successor of the title of the employer or the person that bred, discovered, or developed the variety. So it kind of combines what the US PTO does for applicant and assignee and inventor, all kind of together as one. The novelty bar is a little different than what we talked about for the patents. So it's the same for the US. If you had a sale in the US, you must file your PVP within a year. However, sales outside the US is a bit more. So it's 4 years, 6 years for trees and vines. If your sale was outside the US before you have to file a PVP application. The scope of protection is defined by the statute. So it gives you the right to exclude others from making, selling, or using your particular cultivar in the US. It also protects against using the variety to produce F1 seed for sale and essentially derived varieties. Doesn't stop someone from making or having an essentially derived variety, but a person that does have an essentially derived variety of your variety, they cannot commercialize that without the permission of the PVP holder. There's also some limitations. There's a breeder's exemption. The use, since we're getting close to time, I won't read it all. And there's also a crop exemption, also called the farmer's exemption.
And the breeder's exemption, which says people can breed with it in the US, an important piece is that can be contracted around. So in a license, you can basically overcome the breeder's exemption. At least that's what's assumed. It's never been tested in court, but that's the assumption in the US. The same is not true in many other countries. And for the crop exemption, which says that farmers can save seed to replant, the crop exemption does not apply to asexually reproduced plants. So you can't hold cuttings back to replant a field. It doesn't work for that.
Yep. I was just here's two examples of PVPs. And I just wanted to point out, so the one is to avocado, so that's a tree and it has 25 years term, whereas the second one is cowpea and it has a 20-year term. So that's actually a big distinction of PVPs, or an advantage of PVPs is the term of protection is determined from the date of issuance, whereas the term of protection for patents is from filing date. So you'll get more time just from PVPs, but then on top of that, if your variety is a tree or a vine, you'll get an additional 5 years. So there's some advantage there. So this is our handy dandy comparison of the three types cheat sheet that kind of just goes through everything and compares it in the simplified version.
And we have one more question here. For varietal utility patents, are these available for plant species that are asexually reproduced and would require a tissue culture sample? Yes.
Yes.
That was sort of the technical change that happened. Theoretically, they've always been available. You could always get a utility patent for a asexually reproduced variety. It's just that to satisfy the enablement requirement, there's really no good way to do a tissue culture deposit until pretty recently. Now there are some labs, primarily there's one in Maine called the Bigelow Lab that will take a tissue culture deposit and store it for the required amount of time.
And they'll make it for you too. So all you have to do is send some plant material and they'll make the tissue culture deposit, make the tissue culture for you.
Yeah, and then store it for 30 years. Cost is around $4,000 for the deposit. So it's not crushing. All right, I'll trade you again.
Okay.
We only have a couple minutes left, so we'll see what we can get through. Protections in other countries, this is pretty straightforward. So plant IP rights, like all IP rights effectively, are jurisdiction by jurisdiction. Most other countries or regions use a UPOV system, which is nearly identical to the US PVP system. So if you're in Europe, Europe has the Community Plant Variety Office, the CPVO. That is a UPOV system that allows you to protect your plant essentially with a PVP there. It's called a plant breeder's right, or a PBR. And the system looks very similar to the US PVP system. The novelty deadlines are the same. There are some differences. A lot of countries require in-country DUS testing. So in the US, when you submit your PVP application, you just give the result of the test that you did. In a lot of countries, you have to do that in the country with some form of government oversight. So there are distinctions, but overall, the protections you get are very similar.
We got a couple other questions that maybe that would be the best use of our few minutes here. So one of the questions was, what about overlapping protection and double patenting related issues? So you don't have to pick one of these. You can certainly have more than one. You can have a plant patent and a PVP, or a plant patent and a, utility. And we do that often. It really depends on the business goals, like what you're trying to protect and the best way to go about it. And also if you have some issues, some novelty issues that we need to be creative about of how to avoid. So yes, you certainly can have more than one type of protection. And depending on how you file those, you wouldn't have double patenting issues with a PVP. That's kind of its own thing. But you might have some for the plant versus utility, but that's not that big of a deal, I
And
guess.
interestingly, we've never seen a rejection for double patenting, though, I mean, theoretically, it could arise. But the thing is, the plant patent uses just a form claim. So it's, the plant as described herein. So it's, tough to look at it and say that the claims of the utility patent really are identical to the claims of the plant patent, even though they are going to be largely overlapping. But yeah, we do. If for valuable varieties, it's common to secure more than one type of protection.
There was another question about why choosing the boring name as the title of the plant patent as opposed to the name that you want to commercialize. So this is a really big point. So we don't have time to get into the trademarks part of our presentation here, but if whatever name you use for your plant patent or utility patent to name your variety, you cannot use that as a trademark. And there's huge advantages to getting a trademark on your plant as well. The main being that your IP rights with your patents expire after 20 years, but trademarks don't. So the idea would be that you build your brand during that 20 years of your patent, and then you use your brand afterwards with your trademark. But if you have the really fun, like Stephanie Sunshine as your, instead of SGS 123, you can't use Stephanie Sunshine for trademark protection, and anyone can use it after your 20 years is up for your patent. So
yeah, and to give real world examples, so the Honeycrisp apple, which most people are familiar with, Honeycrisp is the actual varietal name. So when the patent on Honeycrisp, the plant patent on Honeycrisp expired, everybody was free to sell Honeycrisp apples under that name. On the other side of that, the Pink Lady apple, which is another very popular variety, Pink Lady is a trademark brand name. The actual variety name is the Crips Pink. So the Crips Pink patent expired relatively recently too, a couple of years ago, but you still go to the grocery store and buy Pink Lady apples. They have Pink Lady stickers on them. So anyone who sells Pink Lady apples is still paying a trademark royalty back to the original breeding company that developed the Crips Pink apple and came up with the branding strategy for Pink Lady. So there are real world examples of sort of what to do, what not to do. And the market has certainly shifted over the past 20 years to being very common for you to have what we would consider terrible variety names that no one would produce, and then getting the patent or getting the trademark and then using that to extend your royalty stream after the patent expires.
There's another question regarding patentability requirements. Are they the same for a plant patent as for utility patent? Yes, they are the same. However, the scope of coverage is very different between the two. So for plant patent, you really just need to fulfill those requirements for the variety itself, because that's all you're covering. However, for utility application, your claims cover much, much more. So to fulfill those same requirements requires a lot more effort and a lot more care in crafting your application. So the statutes and the rules and the requirements are the same between the two, but the bar is much higher for a utility.
Yeah, and the other piece of that, I think, is it's extremely rare for us to get a obviousness rejection in a plant patent application, because it's sort of inherently non-obvious that you could use two plants and develop that specific variety. So though the patentability requirements are the same, rejections that are common in other areas are just not common in plant patents. And then 112 is very different for plant patents because you can add to the application after filing. So there's effectively no new matter rejections. The patent office will simply ask you to add information to describe this piece of the plant better, and you do that, and that's not new matter.
All right, well,
We're-
we are out of time. I will say that so this recording is available. Krista added that to the chat, and we're happy. Travis and I love these kind of things. We love
Yeah.
talking about this. Counseling is our favorite thing. So please don't hesitate to reach out to us. We're happy to answer if you have follow-up questions from this presentation. Please shoot us an email. We're happy to address it.
Yeah, absolutely. And actually, we frequently will go out to individual companies and give sort of talks on the same kind of thing to educate breeders or the tech transfer people or IP people at a company. So yeah, feel free to reach out if more information be helpful. So thank you everybody for attending. Have a good day. Stop share.